Thank you. That was a great song. That's my walk-up song. Just putting that out there. Hi, everybody. That is Ed's song. I stole it from him. Thank you. Hi, everybody. I'm Dawn Bauman. I'm Senior Vice President of Government and Public Affairs for Community Associations Institute. Thanks for being here this afternoon. We did save an entertaining program for you to end the day. So I'm glad you came back to see it because I think you're going to have a lot of fun and you'll probably learn something along the way. I want to make a couple of announcements before we introduce the facilitator and speakers for today. First, the 2018 Law Seminar will be held in Palm Springs. A little bit warmer, so that'll be nice. January 31st to February 3rd at La Quinta, which is an Astoria hotel. It's going to be beautiful, so please make your reservations and mark your calendars for that. Also, tomorrow morning at 9 a.m., you have a little chance to sleep in, is the College of Community Association Lawyers business meeting from 9 to 9:30. You'll find that meeting in Ironwood 3. And the purpose of that meeting is to give you guys an opportunity to hear a little bit about membership into the college and information about some of the initiatives the college is putting on, including the mentorship program and the amicus briefs. So I hope you'll be able to join us tomorrow morning at 9 a.m. Finally, I'd like to introduce today's moderator of the panel of pundits. It is Andrew Elmore, an attorney from Virginia, shareholder with Chadwick, Washington, Moriarty, Elmore, and Buck. So welcome.
Come on, guys. Ladies and gentlemen, thank you. Thank you for staying at the last presentation of Friday at the 2017 Law Seminar. 6 years ago, a very smart CCAL attorney from Phoenix thought, well, my goodness, one of the purposes of us having this on a national basis is we get all these lawyers from all over the country who we share ideas and we can benefit from the knowledge and experiences that we all have. Why don't we do something more formal about it? And henceforth was born the panel of pundits, Mr. Scott Carpenter. It's his baby. He was the moderator for 5 years. And weirdly, as Scott had some gigantic shoes to fill this year in his role doing case law, so to replace Will and George amongst with his 3 other co-presenters, I've got some very giant shoes to fill of Scott Carpenter. So I'm fired up for the opportunity. We've got a bunch of energy and sass from different parts of the country here. And I'm going to ask each of the panelists, we'll start with Beth, to go over your name, your firm, your practice areas, your practice location, number of lawyers in your firm that do CA work, and how long have you been doing it, and then finally, whether you're a shareholder for your firm or not.
Hi, everybody. My name is Beth Mulcahy. I am with the Mulcahy Law Firm. I am the managing partner of the firm. I started the firm when I was 26 years old. 20 years ago, and our practice focuses exclusively on representing associations. It's 100% of my practice and everybody who works on our team. Other than myself, I have a team of 4 attorneys who are all here today, so thank you for being here. Did I miss any other questions?
No, I think you're good.
Okay.
Scott?
All right. Scott Sandler. I'm a managing partner at Sandler, Hanson & Alexander, located in Middletown, Connecticut. I've been representing associations for about 16 years now. We are almost exclusively an association general counsel firm. My 2 partners, Chris Hansen and Mike Alexander, were not allowed to come because somebody has to work, and it sure wasn't going to be me. And I got the call from Andrew saying, do you want to come and be on the panel? And I said, whose shoes do I shine up here? But yeah, I thought this was a great opportunity. I'm happy to be here. And this may or may not be vodka.
I'm Darcy Mailing with Cayman and Cusimano. We're based in Ohio with 2 offices, started in Cleveland and expanded to Columbus. We have 6 partners, all of whom are here today, along with myself, and 18 attorneys in total. 100% of our practice is dedicated to representing condominium and homeowner associations, and that's how the firm started back when David Cayman began.
Hi, everybody. I'm Ed Alcock from Marcus Arico, Emmer and Brooks in Braintree, Massachusetts. The first thing I have to do today is stand up and finish Steve Marcus's speech from earlier today. He didn't quite get it all out, so I got to finish that. I was born and raised in Pawtucket, Rhode Island, so to pay homage to Dave Graff, who was just phenomenal today up here as part of the case law update. I was going to do a limerick, but I was told I couldn't finish it. It kind of went like this. Oh, no. I'm a condo lawyer from Pawtucket. And they wouldn't let me finish it. So I'm a partner at the firm. I can't remember how many partners we have because we just had 4 of them depart. But it's something like 25. I've been practicing CA law since 2001. I've been a lawyer since 1994. I practice in Rhode Island, Massachusetts, and New Hampshire. Most of my practice is devoted to litigation, but as I tell everybody in my office, we're all condo or CA lawyers first. So I like to think I have some knowledge as to that, but I'm not really sure that I do.
We'll find out.
If not, you can fake it.
Yesterday, President Steve Weil talked about the mentorship program here and being raised in a CA firm and being mentored by a founding member of CCAL. Mentorship is certainly important to me, and I want to ask the panel, starting with Scott, do you do mentorship in your firm? And if you do it, do you have mano-a-mano approach, or do you have a team, or is it just a free-for-all and everybody's got their hands in everybody?
Well, my firm's, as it stands now, it's relatively new. We opened our doors in August. Previously, I was a partner with Matt Perlstein, who is somewhere in the room, and he acted as a mentor. I am working with 2 partners who both have roughly the same amount of association experience as I have, so it's less mentoring and more ass-kicking.
Okay. How about you, Beth?
Well, we're a smaller firm, so it's just myself and 4 attorneys, and I like to think of myself as a mentor for my team. You know, what I see my role is to have them love this practice area as much as I do, and to have it not be a job, so that when they come to work, it's fun and interesting. And I guess my goal for them is to, you know, continue to grow each year that they're with the firm and to like their jobs. And I mean, we're already planning with anybody on our team who wants to be a CCAL, and I have 2 lawyers that are 1-year lawyers, and we're already planning their CCAL path. So we're definitely doing that, and I think I try to be open to them. I mean, we were all young lawyers once. I made mistakes. Hope you're not going to be asking us about those. But, you know, I try to instill in them that it's okay to make mistakes. You're going to learn from them, you know, and just try not to make the same mistake twice. And that's why they call it practicing law. You know, we're all practicing to become better lawyers.
Darcy, all of us as partners of firms, when we hire people, we obviously want somebody who's going to just do a great job, be brilliant, make us all proud, make us all wealthy, and all of that stuff. Have you learned over the years any job interview tactics or strategies that results in getting you the perfect hire?
Absolutely not. When you talk about practicing law, I mean, I think managing and hiring of attorneys is always a more like lessons learned every single time. I don't know if there's a magic formula. There's certainly different characteristics, certainly go-getters, certainly people who are comfortable speaking in front of a group. Our firm really emphasizes a lot of client contact. We are going to meetings at night. Usually at least half the firm's attorneys are out at meetings 2 or 3 times a week. We, on average, do 50 to 100 meetings a year. So it is just ongoing training. To somewhat dovetail off the last question, our mentoring is more of a team approach. All of our doors are open as partners, and while we each oversee a different group, for example, I oversee our collections, attorneys and paralegals, any one of the associates in my department, so to speak, can certainly come in and talk to me, but they're free to talk to the other partners as well. And I think that helps as we help everyone to develop as a community association attorney.
So it'd be accurate to say at your firm you're looking for Jack or Jacqueline of all trades rather than a CA specialist in one area, like, for example, Ed does primarily litigation. How about you guys, Ed? Do you look for specialists or?
Well, as far as the interview process goes, I usually just ask inappropriate questions and see what kind of answers I get, see if they can handle working with Marcus on a daily basis. And really, I don't know, what I'm looking for is somebody who's got it. It's hard to find. It's like who knew Tom Brady was going to be Tom Brady? But it's just that person that has
8 minutes.
It.
It's all it took.
I'm looking for Tom Brady. It's hard to find because they're, you got to wait. Everybody passes on them. But I kind of look for somebody maybe who's got a blue collar approach, because let's be honest, this isn't rocket science. I don't need somebody who necessarily is at the top of the class, but somebody who can carry a conversation, who can think outside the box, and who can communicate effectively with clients and people, and can drink, likes to party, knows their Patriots trivia, things like that. That's kind of the way we do it.
I've interviewed a number of potential associate candidates over the years, and nobody started out their law practice thinking they were going to be a CA attorney. I certainly didn't. I don't know of anybody in law school who said, associations, that's so cool. So what I look for in a candidate, and it's very tough to get to this, but I look for a certain either skill set or a type of interest or personality that I think would serve itself well working with boards, contentious groups of unit owners, and a certain curiosity about learning an area of law that isn't all that popular among legal practitioners. It's very hard to get to those qualities. You have to do some digging and mining and ask some pretty bizarre questions from time to time.
Like the square root of an isosceles triangle.
Yeah.
I have a suggestion on that.
It's a trick question. It doesn't have a square root.
So when we interview candidates to join our firm, I do it two ways. I ask them to take a personality test, because that kind of you don't have to ask inappropriate questions, and we use the...
Where's the fun in that? I'm looking for the inappropriate response.
Right, well, so I like the DISC profile, DISC.
I'm familiar with that. Yeah.
Okay, and there's certain traits that we're looking for in our practice area. You have to be good with people. You have to be able to think on your feet. And there's certain categories in that test that have been really helpful for me to select good candidates. One other thing that I do is that sometimes I'll hire them as an independent contractor and see how they do. Because that's a good way to kind of test drive and see if we get along well, if they're good with clients, if they're responsible, nice. I think nice is a really important quality for
I want to find a son of a bitch.
I mean, I think there's an element of, there's a lot of different challenging situations that we deal with, and being able to be nice under any circumstance to me is very important.
All right, Ed, because you mentioned Tom Brady, you get this one. Your firm does a ton of business with a big management company. You got a great relationship with them, 6 figures plus of business generated a year with these guys.
How do you know this?
And you have a huge client that you've had for 20 years that has a management contract with that management company. And they call you up and say, Ed, we need you to pursue a lawsuit for breach of contract against the management company. How do you handle that?
We have a firm policy on it. We don't sue property managers. So that would be something that we refer out. Rightly, wrongly, the reality is a lot of our relationships are with the management companies. They generate a lot of leads, a lot of business. That doesn't mean we wouldn't tell them that they're wrong or that they're being inappropriate or that they may have committed some breach, but we just don't get involved in it. So what we would do is we would refer it out, usually to a very competent attorney who can handle it.
Usually?
Yes, usually.
How about you guys, Darcy?
I can't say we have a firm policy. We've certainly had to sue management companies, particularly when they've stolen funds from the associations, which thankfully hasn't happened lately, but maybe that's a sign of an improved economy and people don't need to dip their hands into the cookie jar, so to speak. We look at the management companies, though, as part of the team. We obviously don't represent them, and never have, never will. But we do work with them, and if there's a conflict between our client and the management company, like he was saying, we'll tell them, you're in the wrong, we need to resolve this. And if we can't broker a resolution, which in my memory banks, I'm not sure we haven't been able to. I don't recall where we've had to refer out any type of lawsuit to another party.
How about you guys, Scott?
Well, candidly, I often feel like the management company's a bitch. When they screw up, I have to provide, I'm the one who usually ends up eating that bill. Management company misapplied a payment onto the wrong account, sends the owner who really isn't delinquent to me for collection. I send out a demand letter, I incur the cost of a title search, and the owner produces a check, a canceled check showing they paid it. The management company's not going to pay my fees, isn't going to pay my cost. So whether I like it or not, like Ed said, like Darcy said, they're the source of business. I will not represent management companies, but I won't sue them either. I can pull a manager aside and whisper in his or her ear where I see a problem and they may need to take corrective action. But like these two, I'll refer that out.
And of course, sorry, not to interrupt,
No, go ahead.
but even though we have a firm policy, like everything else in our firm, we violate it from time to time.
I mean, like everyone in your firm.
Yeah, and actually we've had, in certain circumstances, we actually have gone after a management company. Usually it's been in connection with a transition from developer control when we can't get access to records or things of that nature. I know, for example, we won't even review the management contracts. We'll refer that work out as well, even on behalf of the association client. We don't want to get in the middle of that negotiation.
How about you guys, Beth?
I can't think in 20 years that I've ever sued a management company, but if we had a situation like Darcy mentioned where there was financial improprieties, that would probably change and we may have to do that. I would say it's a delicate balance because you don't want to lose your biggest, if they're feeding you a lot of work, you don't want to lose that relationship. But what I probably would do would be to listen to the client and find out if the situation was past the point of no return. And, sometimes it is.
Right.
And sometimes it's just, maybe something that's just nitpicking on one board member, and that's just bothering them, and it could be easily resolved with better communication. And then I probably would suggest, hey, let's get together with the manager or the management company head and ask for a manager change. But I don't think it's a good for business to be suing management companies. Definitely not.
Switching gears, looking at another topic, Marcus, in his long speech, mentioned millennials, and we all deal with the fact that, and I'm reluctantly acknowledging that I'm a lot older than I behave or that I think I am, but I realize a lot of my habits are more old school, and I struggle sometimes with the millennial tension amongst employees, particularly with people not being in the office. And is it important in our practice that our clients believe that we are actually in our office, or does it matter? Scott?
I haven't noticed that I need to be physically at the desk so long as I am responsive. We all have smartphones. I've been getting emails for the last 3 days while I'm here, and frequently all I'm doing is acknowledging receipt, explaining I'm out of town at a conference, I'll get back to them next week, and they're thrilled. I may be a younger lawyer, at least I like to tell myself so, but I borrow from the millennials that need to have a happy work-life balance, and I'm old school in that I still like word perfect. So I try to strike a... Thank you. I try to strike a proper balance. There's value from both perspectives. I think we're in an ever-changing environment. I'm not wearing a tie. I don't wear ties to meet with clients anymore, and they prefer that lately. I've asked. They don't want to see me show up in a custom suit. They think they're paying me too much. That may be generational, but so long as they get a response, I don't get the sense from my clients that they want me chained to my desk.
Darcy, related to that, in that, at least I'm a subscriber of the value, particularly in our practice area, of mentorship. We talked about it earlier. How do you balance the benefits of mentorship with the yearnings of millennials to work remotely?
In our office, because it's a team approach with our clients, not one of us has a portfolio of clients, for example. As I mentioned earlier, we divide up our practice in different areas: collections, operations, litigation. It requires us to be working together. We might have one or more attorneys from different departments working together on the same case, or certainly for the same client. And while we certainly can work remotely, and I will readily admit that I take full advantage of that, there's certainly a benefit of being in the office. And I think all of our associates appreciate that. They seem to actually learn from each other as they share the problems or issues of the day, maybe over lunch. We actually revamped some of our office space to make a bigger space that people could just kind of gather, whether over food or just to hang out. We stocked the fridge with more than just water and pop to help relax let people put their hair down a little bit. But there's definitely a benefit to the face-to-face interactions. We've learned to adjust, certainly with having two offices. We're all on the same phone system, so we can intercom from Cleveland to Columbus just like we can from office to office and communicate over the phone, if not face-to-face.
So, Ed, you've got a 6-month associate, been there 6 months. Mr. Alcock, I'm going to work out of home this week, and this person's on your team. Is that good for you?
Would Tom Brady do that? If you need to work for a week, that's fine. I think, part of it is we are building a team, and it's hard to be a team when you're not together and you're not around each other. The email and the texting is great for certain things, but I don't know if you've ever gotten into some of those, what do they call them, streams, or you go on for days back and forth on email when you could just get it over in a snap if you're there face to face. And I do think it's just hard to build a team remotely. I mean, I might as well just hire my cousin Johnny from California if he's going to be part of my remote team. I think there needs to be, I'm okay with the remotely, but I think there needs to be a lot of time around each other, because that's how you bond.
Right. All right, we'll switch gears again. We're going to go legislative. We've got 51 governments to deal with in our industry, 1 federal and 50 states, and they all seem to occasionally mess things up for us. But I'm going to ask Beth, from a community association practice perspective, you get to run, well, you work in 2 states, but you get to run your state government, and you get to eliminate or change one law or add one law related to our practice. What would you do?
That's a hard question. You guys are lucky. You get to sit there and think about it.
I can't wait to answer this one.
IQ test for unit owners.
I think I don't think there's one law that just pops into my head immediately, but I would say there's a bunch of little annoyances in the Planned Communities Act and the Condo Act in Arizona, where my practice is primarily located, that there's just cleanup things. It's annoying when one law says one thing and another law says another thing, and then we've got administrative law judges issuing opinions saying that we can't, do certain things, but we've all been saying that you can do actions by written consent. And so what I would like to do is just do a cleanup. Come in and just do cleanup of what we have would be what I'd like to do if I had more time. And maybe be more proactive, I think, on sponsoring legislation that is going to be beneficial to our clients versus being reactive, which seems to be something that has happened for the 20 years that I've been practicing there. It'd be better to be proactive and be pushing bills, I think, that would be beneficial to our industry versus just always, we're responding.
You're fixing Connecticut. What are you doing?
Well, I think this could work universally. CAI publishes its rights and responsibilities for board members and for homeowners. I would require real estate agents to hand that out to anybody making an offer on a condo unit.
How about you, Darcy, in Ohio?
Easy for me, super lean. We do not have it, and especially even hearing the issues with the assault on the super lien or priority lien issues, it's certainly still better to have it than not. It's been introduced a couple times. I'm the chair of our LAC, and we're trying, but our state legislature has a super majority of Republicans in both the House and Senate and in the governor's office, and we don't get a lot of support from that party for this particular piece of legislation. Secondly, somewhat to Scott's point, I would want some sort of improved disclosure requirements. We had that introduced as part of another bill. We didn't like the rest of the bill, but this piece is something that we'd like to possibly carry forward, where with the real residential property disclosure form, there's an addendum to help the purchasers understand that they're buying into a deed-restricted community.
You know, since Darcy built off my idea, I want to build off hers. Complete priority for association liens. Treat them like taxes.
That would be nice.
It's the same damn principle. Treat them like taxes.
Good luck.
Yeah.
Ed?
I'm a little more selfish. I don't know if you heard, Dave Ramsey talked about a case from Rhode Island where I was involved, and we took 5 trips to the Rhode Island Supreme Court. And by the time we got, I think on my 5th trip, when I introduced myself, the answer I got back from the Chief Justice was, "You again?" And little did they know, while I was there, we had actually put forth a bill in the Rhode Island General Assembly to actually fix legislatively the outcome of that case. And we got it all the way through both committees on the last day of the session. I think it was in the Corporations Committee and the Judiciary Committee. And it was set to be voted on that evening. But the Senate President and the House Majority Leader in Rhode Island got into a fight about a bill involving expanded room for egg-laying chickens. And seriously, there was a bill about making the chicken cages 18 inches wide versus 12 inches wide, and the Senate President apparently had the chicken farmer in her pocket. So what they wound up doing was they wound up shutting down the session that evening, and I guess like 80 bills wound up dying on the cutting room floor. So I didn't get to fix the case. So Dave Ramsey got to talk about it instead.
They balked at that bill?
They did. That's my selfish thing. But I think what I'd really love to see, we have the UCA in Rhode Island. We have the 1977 version of the UCA in New Hampshire, and I'd love to see Massachusetts adopt something, maybe UCA, but probably more likely Ukiah, so we could, in Massachusetts, we don't have a statute that even deals with homeowner associations, only condominiums. And our act in Massachusetts, even though we're a very progressive state, we still have like the 1963 Puerto Rico version of an enabling act, although people like Steve Marcus have been very active in modernizing it in other ways, like for example, the super lien. But I'd really love to see it ultimately be modernized, maybe Ukiah or UCA.
Potter Stewart, former Chief Justice of the U.S. Supreme Court, commenting on pornography, said, "I'm not sure what it is, but I know it when I see it." Beth, have you ever seen the unauthorized practice of law? And if so, what have you done about it?
I have. I cannot say that I have been a leader on this, truly, but we see management companies from time to time in Arizona expanding their roles. And actually, they had legislation passed in Arizona where they can now represent associations in small claims court. But, you know, we see things from time to time where, I mean, I've seen some incredible things. I had a management company ask for my name on a stamp so that they could stamp the liens with my name on it.
Nice.
And so, we do see things, and I, of course, did not give them the stamp.
Good.
But, we see things like this from time to time. There's definitely an expanded role of management companies, I think, looking for fees, to generate more income for their management companies. Many years ago in Arizona, there were some people that tried to exercise some leadership roles and kind of take on them and go to the state bar and claim that there was UPL by the management companies. And I can say that they really had some consequences to them in terms of the business. So that was obviously something that was scary, I think, for the other people to see happen. So yes, I've seen it with management companies, and I haven't done much about it.
How about you, Scott?
I've seen them come awfully close enough where I warned them warned them back from that edge. My mentor was a big believer in the use of creating forms for almost anything we could do in the office, resolutions, amendments, and so on. Now, I've had management companies ask for my form so they can use and reuse it over and over again for their various association clients. And I've refused, saying, you don't really want to do that. And it's not because I want my $500 or $1,000, I do. If you do something good, you don't do it for free. But I also don't want them drafting resolutions and taking on the role of lawyer and counselor when they really shouldn't be. And I think that's just playing into the hands of the owners that like to accuse the managers of wrongdoing. So why give them that argument? Why play right into that argument when all they have to do is for the association to funnel it through my office rather than the management company directly preparing these resolutions or documents?
How about you, Darcy?
We've seen it. Management companies typically filing liens on behalf of their associations. When it comes to our attention, we kindly, gently explain why they should not be doing it and wrestle that away from them. So other than that, we had some issues in small claims courts where some of our associations may have tried to represent themselves, which is permissible to the extent that they can be present, but they're not allowed to cross-examine, for example. And so it's obviously very limiting. More interesting is the bench. The magistrate will actually tell them, you don't need an attorney in here. You can represent yourself in this matter without going on to advise them that they wouldn't be able to cross-examine, for example. So it's been a little bit of a challenge sometimes in the small claims cases with the magistrates themselves.
You again.
Oh, sorry, I started daydreaming after you said pornography.
He knows it when he sees it.
I do. It's on my phone, actually. What we did, we actually had a big case in Massachusetts, and our bar association, and one of my partners, I think, was involved in an amicus brief. We had a lot of notary closings where they were out-of-state closing companies that were conducting transactions and not having a lawyer at the closings. And we actually wound up getting, I wasn't involved personally, but there was an excellent decision from the Massachusetts Supreme Judicial Court dealing with the unauthorized practice of law, and they described that practice to be unauthorized practice of law, and all of the, our Massachusetts real estate bar got involved in that, and again, one of my partners was involved in the amicus brief, and it was a great decision, and it kind of scared away that practice. As far as the property managers go, quite frankly, some of them are smarter than some of the lawyers I know. And sometimes they give practical advice versus, getting bogged down in some of the law. I mean, like Scott said, it's a razor's edge to figure out where the line is. If it's practical advice, I'm okay with it, but I guess I really haven't seen a lot of managers giving legal advice. Whenever they have a problem, they tend to have the sense to come to us.
I don't know if anyone else has seen this, but I work with one or two management companies that have retired lawyers who decided to get out of the practice of law, become managers. And sometimes I have to remind them that they are no longer entitled to practice law.
All right, Ed, I'm going to go back to you with a little football reference here. Trademark of a good coach is the ability to make effective halftime adjustments. You've been practicing law for 20 plus years. Can you comment on any adjustments that your firm has made over the years in light of the changing landscape or clientele or laws, et cetera, that have worked?
That have worked? No. I suppose, I mean, right now we're in the middle of kind of a big change, kind of a big, I guess what you would call, or some people are calling a shakeup. And we're trying to put our heads together to address how to deal with, I guess, what the younger generations are in our firm and come up with a plan for succession. And we're working through it. But other than that, we haven't done anything that's worked yet. But I'm hoping in the future we're going to be able to come up with a plan.
Good. How about you, Scott?
Well, I left one firm to start another. That was my big shakeup.
I have to make the notes.
Pardon?
I think that all of us in this area need to be strategic in how we're running our firms. And I spend a lot of time thinking about strategic marketing, not always doing the same thing that we always did, whether it was lunch and learns or whatever, but what's really going to provide the most effective return on the investment. I think just the millennials question, I thought was an excellent question. I think that we have to change how we are practicing law. And I was, if it didn't get to me, but if it had gotten to me, I would have said, I'm okay with people working remotely. I work remotely. But you got to produce, you know, and you have to service the clients, and you have to be an A player to do that. If you're a C player, as in see you later, no, that's not going to work for me. But if you're an A player, you know, that's working for me. And I think some strategic things that I'm thinking about right now is we're starting to see a decline in the number of collections in Arizona. And that means that we need to think about how we're going to make the shift, whether it's changing people on your team from the collections team to the general counsel team, changing up our marketing, thinking of ways to get new work that might be out of the box. You know, so I think we all have to be strategic, and I think we need to not be stuck in the way that law firms have always run, because things are changing, and if we don't change with it, it's going to pass us by. So I think that's important.
One of the things I like about this area of practice is I feel like it's frequently evolving, it's changing. There are new cases coming out, new statutes being written. It's only recently that the legislatures have really paid much attention to association law. You had the adoption of a number of uniform acts 20 years ago, 25 years ago, 30 years ago, but now associations are in, for good, bad, or indifferent, they're in the spotlight often at the state level. We're seeing it also at the federal level. I chair the Connecticut Legislative Action Committee, and while it's an extremely frustrating position, what I like about it is that things are constantly moving and changing and reshaping. That requires us as lawyers and counselors to be thinking about what changes in advice we need to give our clients, how to counsel them to keep up with the law as it exists right now, which is different from how it existed 20 years ago and could be different from how it's going to exist next year.
Beth, can I ask you a question? Mm-hmm. Do you have a firm that's like split up into departments, like you've got a litigation department, a collections department? Because that's one of the things we have, and I find it to be problematic because you wind up sometimes with inter-office wars, or the litigators run around pounding their chests, and kind of what I think sometimes gets lost is we're all CA lawyers first, and we need to kind of cross-market sometimes within our office, spot issues, locate things that we can generate leads internally from a collections lawyer talking with the manager, and can spot an issue that he doesn't realize that can now become a litigation issue or a general amendment issue or something like that. And quite frankly, that's one of the things I'm looking to try to get our place to change, to have everybody kind of more be focused. Everybody should have that same base of knowledge. Now, it doesn't mean everybody should be able to try a case, but to have the same base of knowledge of what we're doing and what we're trying to accomplish.
That's a really good question. We're small enough that everybody does some aspect of that. Everybody does litigation. Everybody does collections. I think collections, from my perspective, for new lawyers, they have to learn collections to understand community association law.
I think that's a great
Absolutely,
thought. That you bring them in, they go there.
Right, and then that's the base knowledge. And then also one other thing that we do is I look for what are the strengths of the people that are on our team, and I want them to succeed at our firm. I want them to like coming to work like I do. So I want them, we have certain people on our team who are really detail oriented. And those are the type of people that I'm gonna get into like CC&R projects, but I'm not letting, somebody who's more of a people person get off the hook. They still have to know how to do it too on the team. But I try to, move the people that to be in an area that they're gonna be successful in, but everybody on the team needs to know how to practice all aspects of community association law.
Kind of like why Bill Belichick has his offensive linemen able to play every position, right?
Related to this is this whole idea of needing to change and be flexible. 10 years from now, the successful people in this room, the successful law firms that do what we all do, are going to be successful because they've done what? That's different from what they do now. Go ahead.
I would say, again, I like the word strategic. I think that we all need to be thinking about our goals. Everybody should be doing their goals now, right? Because the 5% of the people that do goals in the United States, 95% of the people work for those 5%. So, I think we should be thinking our 1-year plan, our 5-year plan, our 10-year plan. And I think we don't know what the future holds, but I think it's good to be a little fluid in our industry, right? We've got to be able to adjust. The laws change. Maybe I pray that the FDCPA will somehow not apply to attorneys at some point, because that keeps me up at night. But I think that we have to look at trends. We don't want to be the last one to the game. I think we need to be thinking ahead of our competitors in our industry. Where is this going? Where's a good fit for expansion of our firms? What type of people do we need on our team to change as things go? And then you're talking about succession planning. I think you should always have a succession plan in place. Actually, in Arizona, it's required. You're required to have a succession plan for your firm. It's by the state bar. So I think being strategic, planning it out every year, I just met with somebody on my team, and one of the things that we talked about was, what's your 1-year plan? I want to know, what's your 5-year plan? What's your 10-year plan? What do you want to do? Do you want to break off and do another area of the law within our firm? And so knowing what our team's thinking too, because hopefully they're staying, but if they're not, that's great. We wish them well, and we'll help them with whatever they want to do.
Anybody else have any comment on that?
Well, staying current, being fluid, as you have said, Beth, attending conferences like this, and there aren't that many of them. This is where I come to keep myself current, so that I have an idea of what's coming down the road, what the hot topics are, the hot trends, so that I can position myself to best deal with them when it's there. Life is a chess match. You need to be thinking 3 steps, 5 steps, 7 steps ahead. And the practice of law isn't all that different if we want to really serve our clients well. And I couldn't agree more. A succession plan is very necessary, particularly for, as a lawyer is entering the latter portion of their practice, and they want to say to themselves, how am I going to be successful when I no longer want to practice law, if they ever get to that point? I know there's some folks that are just going to die at their desk. I'm hoping not to be one of them.
Beth or Darcy, any comment?
If the question is who is going to be successful in 10 years, I know that we're talking about things like millennials and all that bullshit, which quite frankly, Dave Graff at least told me I could say bullshit up here. But all that changes, technology changes. I know there's a lot of change, but to me there are certain things that are integral to success, and that is continuing to work hard. And working hard might mean, figuring out a strategic plan. It might mean meeting with the clients more. It might mean drafting briefs or being great in court. But to me, that doesn't change. The person that's going to be successful up here in 10 years is going to be the person that works the hardest. Now, it might be it works the hardest at a number of those things or some of those things, but they'll be working hard at something.
I would echo that. I think there's a core value or requirement, and that's just being able to service the clients. And maybe it's embracing new technology, staying up on the trends, staying educated, but it all goes back to helping the client and help them kind of go through all these different changes as well. I think yesterday Laura put it the best by saying it's so technical anymore, what we see in the case law updates. There are a lot of general themes that have somewhat been established, and now they're getting into the nitty-gritty. I appreciate being in a medium-sized firm where we can specialize a little bit. It allows one of my partners to become the expert in the FHA landscape, allows me to focus on trying to stay out of the fair debt trap, and together we are able to service our clients. So I think 10 years from now, a firm in this area, because of all the different types of disciplines that come to play for our clients, will be best served if they have that flexibility and the numbers to be able to support it.
All right, we're going to switch to a new section, and with compliments and apologies to Mr. David Faraty. This portion of the presentation is going to be known as rapid fire, and I'm going to hit you guys with questions that are designed to have very short answers or maybe one-word answer. I will let you know if I want all four of you. If I don't say anything, I have all four of you to answer. So we'll start going from left to right with Beth. 1 or 2 spaces after a period.
2.
Scott.
2.
What's a period?
That's what I thought. This is for Scott and Ed only. Boxers or briefs?
None of the above.
Oh, commando. All right. Boxers or briefs for you?
Commando.
All right. Beth, the billable hour, here forever or gone tomorrow?
Here forever.
Hybrid.
Hybrid, all right.
Hybrid.
Gone forever.
All right. Best employee benefit in your firm?
Flexibility.
I'll second that.
Flexibility. Good answer.
Getting to go to the law seminar.
All right. Least favorite part of your job?
Dealing with employee conflicts.
Collections.
Discipline. Employees.
Discipline?
Discipline or dealing with
Okay.
conflicts and problems.
Conflicts.
In office or with clients?
Oh, internal.
Okay, internal, all right. Beth, you will retire at the age of what, and has this changed since you began practicing?
Retire from this position? Like being a community assistant? You know, I have no plans to retire.
You just talked about succession plans.
I think the way I would see it is that I really like going to work every day. When I don't like going to work every day, then it's time for me to make a change.
All right. Scott?
As soon as possible.
I have no plans for retiring yet either. I've also been in a position to be able to switch from collections to the legislative. I really enjoy that. I'm going to lobby my partners for the Stephen Marcus program where I take a year off, but I'm not sure that'll go very far.
Ed?
When I reach the age of 18.
Okay. Early to bed or early to rise?
Early to bed.
Scott?
Bed.
And early to rise.
I'm the night owl.
All right.
I go to bed late and get up early.
All right. Very good. Assessment collections, contingency, hourly, or hybrid?
Hourly.
Hourly.
Hybrid.
Assessments? We do a flat fee.
Flat fee. All right. Favorite law seminar moment?
This is so embarrassing.
You could say right now.
I was a young attorney, and I was on a panel with John Epstein, who's not here today. And I was like 27 or 28, and we we did it on, I think it was on premises liability. And my dad came to watch, because it was my big moment. And this is probably my least favorite, but I think it was kind of funny now, 20 years or whatever later. We're talking about these cases, and it was in the big room like this, and somebody stood up, and I was talking about this case, and he said, that case has been overturned. And you're saying this is before technology, so like you can't look it up, and I just wanted to absolutely cry. John was really nice about it, and like basically was like, that guy is such a jerk, and he said it right into the microphone. But the best moment was my dad stayed afterwards, and this is when they had the sheets that you would fill out, and I went up to my room to cry, but my dad stayed and filled out like 50 sheets saying, you need more young people on this panel. You need more young people. Beth Mulcahy did such a good job. So yeah, that's why I'm back here today. I got a good review that day.
So rig voting is still alive and well. Yes.
Yes.
Go ahead, Scott.
Well, a few years back, a seminar we held in Palm Springs with a few colleagues who shall remain nameless. After 11 o'clock p.m., jumping into the closed pool area by scaling the fence and taking a dip.
Awesome.
Bonding moment for legal colleagues.
Darcy.
Getting the CAI room rate for Mardi Gras in New Orleans.
All right, Ed.
2007, Vegas, Venetian. We were supposed to go to dinner, and Marcus didn't show up. He'd been drinking with me all day, and he wasn't responsive on his phone. So we kind of panicked, and we had somebody go up and enter his room. And I knew where his room was, so I got kind of behind them, followed them up. And they enter the room, and they're like, we need a robber up here. He's not responsive. And then they kept shaking, and we're talking, and all of a sudden I heard, who the hell are you, and why are you in my room? At which point I slinked away, and we went to dinner.
With respect to our community association practice, you get to change one federal law. What would it be?
The Fair Debt Collection Practices Act.
Scott?
Either that or, again, complete priority for assessments.
Fair debt.
Federal law?
Yep.
I guess I'd say fair debt.
What superpower would you like to have? You get one.
Do we get to pass?
Sure.
Flight.
Flight.
We'll come back.
To be able to see that crystal ball.
No, I say flight too, or time travel. I don't know if time travel is a superpower, but I'd take it if it was.
Okay. You get a free pass on that
Thanks.
one. It was actually an easy question. All right.
How can you not want a superpower? I got like multiple. Can I take hers?
Dude, every question you get like 3 minutes before it gets to you, right? You've got your notes written out.
Ed,
Oh, you want to start with me now? Come on, let's go.
Who's seen my tattoo?
I'm going to be in trouble with Beth for this, so I'll start going the opposite direction. All right. Your favorite venue for the law seminar, Vegas, New Orleans, Palm Springs, Tucson, or somewhere else?
Earlier I would have said Vegas. Recently I've found New Orleans to be more fun.
Darcy?
New Orleans.
Of the places we've been, New Orleans. Of the places I'd like to go, the Caribbean.
Oh, all right.
I like the ones that are a little closer, so Vegas, Palm Springs, Tucson.
Okay. If you could change one thing, Ed, about the law seminar, what would it be?
Nothing.
All right. Darcy?
I'd start the classes later.
I'd have a drink right now.
I would say more practical business advice about running a business.
Okay.
So at least some breakout sessions on that.
All right, our last rapid fire, I am going to start with you. Patriots or Steelers?
Packers.
Patriots.
That is a no-win for me. I'm in Cleveland.
The Browns.
Yeah, the Browns.
All right, Ed, you don't have to answer.
We are all patriots.
All right. And, Matt, I know you were going to fire some questions from the audience up here. Feel free when you're ready. Meanwhile, I'm going to go back to Scott and say, answer this. You're at a client board meeting, and there are 20, 30 irritated owners, irritated at the board at the meeting. They're not there to tell them they're doing a great job. And you know that the board has done some procedural defect, clearly in violation. And you know the rascal in the audience knows that you know that, or at least knows that you should know that. And he calls you on it at the meeting. How do you handle that?
If I know about it before the meeting takes place, I have a conversation with the board ahead of time. I tell them to get out in front of it, to own the mistake. I don't know.
You're changing the question. The question was at the meeting it comes up.
But in the hypothetical, it didn't say whether or not I know ahead of time.
Yeah, you just
So I'm starting with if I know, I get out in front of it. If I don't know, then that's a very interesting point. We're going to have to look into that. Because what else can you say other than oops?
How about you, Darcy?
Similarly, if we know, especially if we know that owners out there, ahead of the time, we'll try to pull the owner aside and say, we understand there's an issue that you're aware of. We're working on it with the board in hopes that it doesn't come out in an open meeting and disrupt the whole meeting. But then if it comes up spontaneously, then like Scott, we would say that's something we'll need to look into and get back to you.
All right, we'll go through a few audience questions here. This is interesting. Ed, have you noticed any competition from LegalZoom?
No.
Panel, going down the line.
What's LegalZoom?
What's LegalZoom?
No, I have not.
All right. Does your firm have a marketing tagline?
Yes, communicate, don't litigate.
Ours is we represent 4,000 associations, one association at a time.
Okay. Scott?
Providing high-quality legal services to associations throughout the state of Connecticut.
We're the education leaders.
All right. We're seeing nationwide that some management companies are continuing to get bigger. They're going from local to regional to national. Are bigger management companies serving the best interests of our clients? Is that a problem? Is that an issue? I'll start with Ed, because you felt picked on.
I would say, are they better? Bigger's not necessarily better.
That's what she told you, isn't it?
At least as far as management companies go. I don't see any reason why a bigger management company can't do the same decent and appropriate management job and provide the same level of service that a local one can. But I think it's probably harder for them to do so. As long as they're not engaged in the practice of law, I don't see an issue with it.
Darcy?
Definitely seen where the larger management companies can offer more of the bells and whistles, more services maybe directly to the owners. They definitely have training opportunities, but we've also seen that if they don't, again, pay attention to the core responsibilities of managing the local associations, and they lose that person-to-person contact, because the management company is, at the end of the day, evaluated by how well of a job that manager communicates with those board members, then they lose the business.
How about you, Scott?
I'm falling back on that old legal answer I learned my first year of law school. It depends. A larger company may have more negotiating power, may have larger amounts of resources, may be able to attract a higher quality of manager if they can pay more. On the other hand, a smaller, more local company may give the association much more personal attention, may know the local players better in terms of vendors and contractors. So I think it's going to depend on the size of the community, on the amount they're willing to pay for service, and the quality of the individual managers over the size of the company.
I would agree. I think it depends. I think there are pros and cons on both sides. I will say that I have heard complaints from clients. They'll say, well, now the accounting is, 5 states over, and,
Texas.
yeah. And so I think there's some challenges with it, but I think it can work for some associations. Some want more personal attention where they're going to have a local management company, and some want the bigger, largest management company in the United States. It just depends on what the client wants.
It's funny, what I've seen in the recent model down in New England is the larger management company purchasing the already existing management company and keeping in place the same people and the same structure, but moving portions of it, like you said, the accounting to wherever they're based out of, and then using their size to be able to leverage better contracts or better services. So in that respect, it's kind of worked out for some of them, or at least I think some of the clients I've had are happy with that. But that's kind of a mix. That's large, but keeping already the existing local people and structure in place.
This is a very relationship-based business, both what we do and what the managers do. So it's more about the quality of the communication between the manager and the board or the individual owners that will determine how satisfied the association is generally and the feedback they'll get from the individual unit owners. And it's one time I'll agree with that size doesn't matter.
We'll go down the line, starting with you, Beth, on this one from the audience. We haven't talked about billing yet, but question is, are your billing requirements and related bonuses calculated on, quote, billing out the door or based on revenue?
I'm not sure I understand what billing out the door is, but it's based on, the time that they actually bill. And then they get an add-on for doing marketing for the firm, and it's based on a number of hours per month that we have a formula. And it works really well. Good. I think from my perspective, it works really well.
We're struggling with, but trying to find a formula for putting a value to the non-billable administrative tasks associated with running a business and the amount of revenue you can generate for that business. There are different ways of generating the revenue. That's why I said earlier, hybrid, when you asked about the billable dollar. There are some things you do on a flat fee and you can earn a premium on your time, and there are some things where it's so unpredictable what the end result will be or how long it'll take to get there that you have to do it on an hourly rate or you'll go broke. So in my firm, we're trying to strike a balance. We're still working through these issues. We haven't yet gotten to a point where we are writing bonus checks. I'm hoping it'll be a good problem to have.
Darcy?
We structure our bonus on several elements. One, certainly billing of the individual attorney for our collections and even some of our operations attorneys who work with paralegals. Then they get credit for what we call team billing. We also have a component, the non-billable requirements of being a CA attorney, meetings, writings, the things that help what I think of investing in the business. We recognize that. And for the associates that are really running the meeting mill, where they're going to 3, 4, sometimes 5 meetings a week, and we kind of set a target number, and if they exceed that, they can earn additional bonus money for that.
Pardon?
Yeah, we hate billable requirements. We have them. I couldn't even tell you what they are. They're so low. Because what we find is if we emphasize those, the hours will be billed. The hours will be billed, but whether or not the work gets done, whether or not the product is good, whether or not the clients are happy, doesn't necessarily correlate with how many hours are actually billed into the time slips program. So we look at a lot of things. We look at, are the clients happy? Are you good in court? Have you been successful? Have you done the extra CAI stuff? Have you been out there writing articles, everything. Again, kind of looking for that total package, the proverbial 6th round draft pick named Tom Brady.
All right, back to you. We haven't covered this topic yet either, which would be ancillary or non-CA related practice areas. Has your firm dallied in that at all? If so, any successes or any failures?
The answer is yes. I think there's a lot of things that are related to CA practice. For example, it's easy in litigation. I'm a litigator, And there's a lot, as a CA litigator, we can litigate any number of things. It could be a construction defect case. It could be a zoning case. So I've seen us handle a bunch of zoning work, development work, real estate related work, pretty much anything I think that touches the dirt. You got to be careful of conflicts when you're representing developers, but if it touches the dirt, I see it as being complementary. We don't like to do closings because we find we get into conflicts and it doesn't really pay that well. But things that are related to the dirt, I think, can complement the CA practice.
How about you, Darcy?
We certainly are open to ideas and we explore areas, but to date we have stuck with just representing condominium and homeowner associations. I said our tagline was communicate, don't litigate, but our motto is we do one thing and we do it well. And that's worked for us, but we definitely, we have people that within our partnership that we explore other ideas, but we keep coming back to representing condominium and homeowner associations.
Scott?
We are CA attorneys. We don't know much else about anything else.
Okay.
So we don't try to stretch into other areas of law where we're not comfortable, where we don't feel we're dallying and it's dalliance for us. What I like to do is build strong relationships throughout my fellow members of the bar who do handle other practice areas, because I'll get referrals from them, I'll give them referrals, and it works very well. And I'm from a small state with a small bar. The condo lawyers in my state get together for dinner several times a year, and there are at most 18 of us around a table. So it's a small bar generally, and I find I do just as well developing relationships with lawyers in other practice areas who are going to refer me their condo business as I'm referring them their real estate closings or their personal injury cases, or asking them to help me out when I get a speeding ticket.
I agree on the referrals. I think that's an excellent point, and we do that. In terms of generating additional income for our firm, there have been different times where I have thought about expanding into other areas, such as landlord-tenant, representing nonprofits, estate planning, which I think are all really good crossover areas. But I think I always come back to the fact that we do community association law really well, and we like it, and it's profitable, and we have a lot of work. So it doesn't make sense to me just to grow when we have plenty of work right now. Now, if something changed where some work started to dry up, I think a really good crossover is landlord-tenant law, because it's form-driven. It's the same skill sets, basically, and the tenants are kind of like the angry homeowners, and so I think that would be something that I would definitely consider going into.
It's funny that you mentioned that, because we actually had a whole landlord-tenant department, and it does seem like it would be a good fit, but it wound up not working because of the time that was needed of lawyers to be in court, like on whatever these eviction days were, the Thursdays or the Mondays and the Tuesdays. And our people, we represented a bunch of national, I guess, apartment building owners. There's a few names out there, and they kind of beat up the fees, and they made it. We were using our attorneys for 4 or 5 hours in the morning to handle these summary process trials, and then we could only bill for an hour of it, and then they could have been doing the CA work. So in our situation, I think there was like 6 or 8 of them. It just wound up not working out in our situation, but it's definitely doable. But maybe we weren't able to just make it work.
I think the better match is the referrals, because I have other lawyers that I'm feeding work to, estate planning, a lot of estate planning. I think that's a good crossover. And then they say they get a good, juicy HOA deal, and then they say, oh, you've got to go to Beth. So I think keeping those relationships up outside of your practice area is really important.
All right, Beth's going to get the most time to prepare for this, but I call this my wrap-up question for a retrospective look from you guys. We have 5 minutes left, but Ed, you've been doing this for over 2 decades. Knowing what you know now about your firm and about you as a lawyer, what would you have done different? You're 1 year out and you're starting this journey.
Nothing. I actually like where I am. I like what I do. I like the people I work with. I like all the people I've met here. I'm actually proud to be where I am and happy to be where I am. So I'm not looking retrospectively, I could have done this, I could have done that. I'm actually happy with what I got, looking forward to just try to improve it.
How about you, Darcy?
Take the Florida bar exam, where I could have been retired and still maintained a practice.
Scott?
With zero disrespect or offense intended to my former law partners, I would have gone off on my own a little sooner.
There's not much I would change. You know, I think everything happens for a reason. I do think that I wish that when there was not a good fit for employees, I wish that I had made a change or talked to them about looking for something different that would make them happier sooner. But in terms of, I feel the same way as Ed. I feel really blessed to have gotten into this practice area. It's fun. I like it. Every day is really interesting. And I wouldn't change any of that. But I think, and one other thing I would say is I wish that I had gone and thought a little bit more about the business side of running a law firm. I wish that I did the JD MBA when I went through law school. I think that if you know of anybody that's going to law school, really encourage them to do that, because a lot of what we do as a managing partner is we're running the business. And if you have that skill set right from the start, wow, that's really going to be a nice thing to have in your pocket.
To follow up on that comment, I think Steve Marcus would say I would be remiss if I didn't mention that Jake Marcus is graduating from Miami Law School with a joint JD MBA. So he's probably perfect for anybody who's looking for him.
Thank to all of you, the panelists, very much. Thank you for staying at the last session, folks, and enjoy your Friday night.